Hi, my name is Ruby Powers, board certified immigration attorney with Powers Law Group. This is our weekly Facebook Live summarizing the immigration news for the week, what you need to know. It's September 28th around 3 p.m. We'll have the Spanish version soon after this one. If you have any questions, feel free to give us a call at 713-589-2085 or post a question in our Facebook Live and we'll try to cover it in this time. So it's been a busy week, like most weeks, and not just in immigration, but we'll focus on that. I mean, we still have the nomination of a Supreme Court justice going on, and that could affect immigration later on, so that's always something to watch. One of the first things that we wanted to talk about was the public charge. So basically on Saturday night, the Department of Homeland Security sent out their proposed regulation for a public charge. We had been waiting for it all year. It's still not up for review yet. It hasn't been posted or published, and it's not law, so that's what's really important. So previously in the year, there was a lot of leaks about what it would look like and how it would impede, or the requirements that would potentially impede someone from gaining legal permanent residency or green card. So this is a little bit more moderate that's been proposed. It still isn't law, and it still would have a 60-day review. So some of the things that they've talked about, so public charge is a term that they use that if a person's not capable of taking care of themselves monetarily by themselves, that they would need a sponsor. And even if they had a sponsor in the past, if they had a sponsor and they met the economic threshold, that was generally fine, or getting a joint sponsor. But what they've been saying is that they're going to go even beyond that. If a person used benefits for themselves and they went below a threshold for monetized and non-monetized benefits in the last, there's a three-part test, and one of them is if they had it in the last, let's see, let me get it up, because I've been reading this stuff all week long, and I've been talking to reporters because it is definitely confusing. And I think what has really happened is most people have gotten fearful about taking any benefit, and the second point is it's caused a lot of chaos. And I think that that was more or less the intention of this, unfortunately. So there's a three-part test. If there's an individual use of monetized benefits, so that's basically like some type of cash assistance in a way, over the last 12 months that total more than 15% of the federal poverty guidelines for a single person household, or if there's individual use of a non-monetized benefits, so that could be other services and things, for 12 months in the last 36-month period. So in theory, this could be retroactive in the past, or if any individual use of monetized benefits plus individual use non-monetized benefits for more than 9 months in any previous 36 months. Okay, so basically what I just said, it's confusing. And what I'm also afraid of is that adjudicators, attorneys, clients, everyone is going to be confused by this. There's a lot of leeway for discretion about negative factors and positive factors. For negative factors, they talk about if someone has work authorization but they're not working, that's a negative. Or if they have a medical condition, then they don't have medical coverage, that's negative. Positive is just basically if they make over the threshold for economic, for the poverty guidelines, like 250% or more. Bottom line, it's not the law. It hasn't been proposed. If you're concerned, do some reading. We'll keep updating you on as much as we know. I really think that we don't need this because most people are not eligible for the monetized benefits in the first place. I don't think this is going to save a lot of money for the government. I think this is actually just going to cause a lot more chaos and a lot of people not getting benefits for children, the U.S. citizen-born children, who need these benefits. People are asking me, should I get Medicaid for my kid? Should I do this and that? You know, I really hate being put in a position where I'm not a doctor. I don't know what's best for your child, but in general, we've been saying for the last few months, try to get off benefits if possible without putting your life and your family's life in danger. And that's really up to you to make that call. But the bottom line is we do not have has not been proposed, and we do not have a rule yet, but it will be coming soon. But if you have any questions, feel free to give us a call for a consult. The second thing, and the one other thing that they haven't decided yet is what to do about CHIP. They haven't figured out if that's going to be. So whenever they do come out with posting the proposed rule officially, that will be up to us as advocates and you as the community to make our comments known so that they could potentially make those changes and make it less onerous of a public charge. So let's move on to the second point. This one had been something that we've been hearing about. It's about notice to appear. So earlier in the year, they had said that USCIS will soon be able to issue notice to appear. They don't normally issue it. It's generally ICE. And so then they said that this will, that they would change who would be able to issue it. Why does this matter? Well, basically USCIS might deny an application, and then the case would be processed to ICE. They would issue an NTA. There would be a little bit more of a delay, a little more time for appeals and processing. But now this could speed up the process for someone to be put in immigration court. So this, they had said they would put it on hold, but it actually says they will now roll it out beginning October 1st. On an incremental basis, according to the agency's announcement. USCIS issued the policy memo in July, remember, that strengthened its enforcement capabilities, normally with ICE, and now threatened to relieve rejected visa applicants to face removal proceedings in court immediately upon denial. So normally, I remember a few years ago, like 4 or 5, there usually would be a notice to appear about a month after a denial of a case. But then in the last few years, we haven't seen that as frequently, not a lot at all, not very much. And so now what I'm also concerned about is, how will that work with that window of time for appeals? Because you generally have about 30 days, most applications, to file a motion to reconsider or appeal. The memo allows USCIS to issue a notice to appear and its applicants who presented insufficient evidence on a discretionary basis. So couple this with the fact that now they say they don't have to issue, USCIS says they don't have to issue a request for evidence. They could just deny your application. So then you basically could apply for something, not get a chance to fix it if there was some minor issue of some sort, go straight to denial, and then go straight to court. So one of the things to know is that you've got to be careful. If you're using a notario or someone who's filling out a form or trying to do this on your own and you're not really sure what's going on, the consequences can be very dire, more so than ever before. I mean, in general, notarios are trying to do things on your own when you don't really know. It can be very hard to try to fix the situation later on. So that's basically what I want to say, is that now they're rolling it out starting Monday. And incremental or not, it's something that we need to be prepared for. And once you receive a notice to appear, that means notice to go to immigration court. And with all the other memos that we've been receiving about not getting continuances and not getting terminations, I mean, once you're in court, it really comes down to, generally, you have to either win your case, your form of relief, or you could get an order of deportation. It's not always that so black and white, but that's where it seems to be going in that direction. So, and also one quick note, a lot of people don't realize about changing address. If you change your address with the Postal Service, it does not mean you change it with USCIS or with the court. Once you have to change your address with USCIS directly with USCIS, and if you ever get put in removal proceedings, you have to change it directly with EOIR for your court. That causes a lot of problems. So the third major note we wanted to mention this week was just the funding for immigration crackdown is at an unsustainable rate. President Trump's crackdown has not come cheap, according to an NPR article. The cost of ICE has its own airline operation to fly deportees back home, and it's $107 million over budget. 10 times a week, an unmarked white jetliner lands at the airport in Guatemala City and releases 100 or so unhappy passengers. They enter the Guatemalan Air Force Terminal. So the numbers, and an Inspector General's report 3 years ago calculated the cost of charter flights at $8,500 per hour, regardless of the number of passengers. We've already been seeing this about numbers for detaining children at unprecedented rates, and that money has been taken away from AIDS and other medical research, and even FEMA, to help cover all of the costs, the rising costs of detaining children, and for this deportation machine. So, I mean, like I say almost every time, is get an experienced immigration attorney to help you if you're in a situation where you need help. And make sure that you, even if you don't think you can afford an attorney, you never know, you might be able to, because a lot of them have payment plans and have reasonable rates, considering the amount of time you could lose if something goes wrong. And there's another point: the premium processing rate is going to go up on Monday. So anybody who needed to file the premium processing, you probably already got it out by yesterday. For today's acceptance, the rate goes up just a couple $100 or so on Monday. I think I covered most of the news. I don't know if we have any additional questions. Some of our next speeches, we are always available to speak to the community. If there's a Chamber of Commerce, a community group, we go all over the Houston area, as well as in the New Jersey area as well. So I'll be up there October 14, 15 in New Jersey. If for any events, we're available for that, as well as any attorney here is open for presentations. And we don't charge for our presentations. We come out to the community. So if you know a group, I mean, we keep up to date with all the news as much as we possibly can, and really connected with the immigration attorney and advocate community. So we try to give that to you as much as we can. I'm trying to think if there's anything else, but I will be speaking in November in Costa Rica for the ALA Fall Conference, the Texas chapter, and again at the Advanced Citizenship topic at the Advanced Immigration Conference for the State Bar in January. And I think we've covered everything. We will be open this Saturday if you want to give us a call for consultations at 713-589-2085, but you have to schedule in advance. But that will be tomorrow, Saturday, September 29th. From around 9 to 12, we have consultations if you want to schedule. Again, we do asylum, removal, family, employment, investment, everything within immigration, and we have 4 attorneys who have lots of experience. So if you have any questions, give us a call. We'll be on with our Spanish Facebook Live shortly. Hope you have a great weekend. Enjoy this weather. Be safe and have fun.